This lecture is about requirements contracts, output contracts, and exclusive dealing contracts. An illustration of a requirements contract is as follows. Let's suppose that I am the owner of a restaurant and I sell salmon to my customers at the restaurant. And you are the owner of a fish company. You have boats and you go out in the ocean and you fish for salmon and you bring them into your company and you sell the fish to various restaurants, including mine. Now we have a contract, and the contract says that I will buy all the salmon that I require in my business from you, and the contract also says you will sell me all the salmon that I require in my restaurant business. Okay. That is a requirements contract. It's a requirements contract because I am promising to buy all of my requirements exclusively from you, all of my needs from you. Now, if I say I'm going to buy, excuse me, if I say I'm going to buy all the salmon that I wish from you, or all the salmon that I want from you, that doesn't work. But if I'm going to buy all the salmon that I require or need in my business from you, okay, then, and you agree to sell me those requirements, that is a requirements contract. Now, the price doesn't cause it to be a requirements contract. It's what I just mentioned that causes it. The price can be set at the time of sale. When I actually have requirements, we can say market price at that time, or we can put a formula in the contract to control the price. But it's not the price that's critical here. It's the fact that there's two promises here. I am promising to buy exclusively from you, and you are promising to sell me all my requirements. Now, an output contract is similar but a little bit different. And the output contract, let's suppose that I am a farmer and I grow tomatoes. And you are a tomato canning company and you've got an operation nearby. Well, you might very well go out to all the farmers who grow tomatoes in that area and say to each farmer, I will buy your entire output if you will sell exclusively to me. Okay, that's an output contract. I will sell you, I have to sell only to you, and I sell it all to you and you have to buy it. And the two legal detriments there you have to watch for is that number one, I must sell exclusively to you, and number two, you must be obligated to buy it. That's a requirement, that's an output contract. And finally, the exclusive dealing contract is similar but a little different also. That's a case where I am, for example, a manufacturer of clothing, as in Woods versus Lucy Lady Duff Garden, you know the case. And I manufacture clothing. I'm in Europe, and in England, in fact. And so I make a deal with Woods, where Woods, you can have the North American territory to distribute my goods there, and I will not give anyone else the right to distribute in that territory. And so Woods then accepts this contract, and what happened in the real case is they made this contract, and it said pretty much what I just said. And then later, Lady Gordon Duff gave those same rights to somebody else for North America, and Woods sued. And Gordon Duff defended on the grounds that this was an illusory contract because Woods didn't promise anything back, that we promised to sell to him and so forth, but he didn't promise to do anything, and so it was illusory. And the court said, well, Woods impliedly promised that since he had the exclusive rights to sell in that territory, that he was going to use his best efforts to sell things there. And that was an implied promise. And so you see in all three of these cases, you have promises. You need to recognize those promises. In the requirements case, I promise to buy exclusively from you, and you promise to sell to me. In the output case, I promise to sell exclusively to you. You promise to buy them all. In the exclusive dealing case, I promise to sell to you for distribution in a particular territory, and you promise to do your best efforts to sell, or reasonable efforts to sell in that territory. And that's what those contracts are about. There are basically two classes of problems that occur on examinations regarding these problems. And the first class of problems have to do with whether or not these people have in fact formed a requirements or output contract. It's usually one of those rather than an exclusive dealing contract, but it could be either. But the first class of problems is, did these people really form a requirements or output contract? And you've got to look for those components that I just told you about. I'll give you some examples in a minute. So the first class of problem, did these people form such a contract? And secondly, what do you do about the quantity term? Because normally, if a contract for the sale of goods, you're specific about the quantity. But if you talk about requirements and output, the quantity is going to move all over the place. What are the kinds of problems that arise regarding quantity, and how do you deal with those problems? And those are the issues that come up with these contracts. And let's talk about them now so you'll understand how to deal with those on an exam. Let's go back to common law, earlier common law, where the court simply would not recognize these kind of contracts. And they wouldn't recognize the contracts because they said they're illusory. And they're illusory because if I promise to buy all my requirements from you, well, maybe I won't have any requirements at all. And so then the argument was that the whole thing was illusory. You're not getting anything out of it. And so the courts bought that for a long while. But that has changed now. And the court says, no, these contracts, these requirements contracts, for example, are not illusory because I'm incurring a legal detriment when I promise to buy all the salmon I require from your fish company. So I'm giving up my right to buy elsewhere, and when you promise to sell me all that I require, you're giving up your right to say no when I want to buy stuff from you. And the court says that's enough consideration on both sides, and that these types of contracts are enforceable. You need to be aware that on bar exam questions, almost all of them that in requirements and output contracts area require that you make an argument to imply the exclusivity. For example, or some part of that these two promises you have to form the contract, at least one of them is going to be an implied promise in about 2/3 of these questions. And so you've got to make the argument that there is an implied promise. For example, suppose I am a country that wants to build a nuclear power plant to provide nuclear power. And I want to buy some enriched uranium. And you have to enrich the uranium about 20% enrichment for reactor-grade uranium. And if you want bomb-grade uranium, it's about 90% enrichment. So these people want some 20% enriched uranium. And so they make a deal. Let's suppose there's only one company that's doing this in uranium enrichment. So they make a deal with this company, and the deal says the company will supply me with all the uranium that I require in my business. Okay? So if they're going to supply me with all the enriched uranium that I require in my business, and I do not expressly say I'll buy exclusively from you, but there's no place else I can get it, well, you can clearly imply the promise that I'm going to buy exclusively from them. And in these bar questions, it's almost always the case that you've got to find an implied promise in order to get the output or requirements contract. So watch for that. Watch for two things here. One is that there is no return promise. I will supply you with all the gadgets that you need, all the salmon that you need in your business. I'll supply you with all that you require. And you start buying from me. Well, you didn't promise back that you would buy exclusively from me. You're just buying from time to time. And so you must distinguish that. And then but if you can find an implied promise that you are going to buy exclusively from me, now you have a requirements contract. If you don't succeed in that implied promise, you don't have a requirements contract. And the questions very commonly require for you to do that, so watch for that. So in the creation of these contracts, then the two things that you want to keep in mind are, number one, that there is consideration, and it's what I told you about, and secondly, that the promise to buy exclusively or the promise to sell all your requirements, one or the other is likely to be missing, and you've got to try to imply that that promise is there. And if you succeed, you got a requirements or an output contract. If you fail, you don't. And the question will be set up on the exam so that you have these two branches. You go one way if you succeeded in finding a requirements contract, and it goes another way if you didn't. And you have to take both of those branches to get the maximum points. Now, so that's how we form these requirements contracts. Those are the problems we have with forming them. The next problem, as I mentioned, is with a quantity. Now, the requirements and output contracts don't give a specific quantity, and so what do you do about that? And the answer is that the UCC has a rule at 2-306, and 2-306 says, here's what you do. It says, when we made the requirements contract, let's go to the case where I own the restaurant, and I'm buying fish, all the salmon that I need, I'm buying it from you, and you promised to sell it to me. Well, at the time that we made this deal about me buying all the salmon that I require from you, at the time we made that deal, we had some idea of about how much salmon I was going to buy from you. Okay, we had some reasonable expectations. You know, it wouldn't be precisely right, but we had some. We knew what I had bought in the past. You know what restaurants in this place normally buy. Or we made an estimate to give so somehow or another you can get some approximations of what you expected. And what the UCC says at 2-306 is that you can't vary unreasonably from that reasonable expectation. You cannot deviate disproportionately, unreasonably from that. If you go too high above that, the other side doesn't have to honor your request, your demand to buy or sell, whatever it is. Pardon me, but you can go all the way down to zero. You can have zero requirements because I can go out of business. And if I go out of business, I have no requirements at all, and so it can go all the way down to zero. So it doesn't have as long as it's in good faith. Now, the good faith is important. When this is on the exam, there's always going to be a good faith argument. And so, but if my requirements drop precipitously in good faith, then that's just the way it is. But if my requirements drop precipitously because I'm manipulating because I don't like the contract anymore, that's not a good faith. For example, there's a case where an oxygen company provided oxygen to a steel company. And the steel company used the oxygen to heat the stuff to make the steel. And so it was a 2-year contract, and the oxygen company, the deal was the oxygen company would provide the steel company with all the oxygen that they required for the next 2 years. Well, about 1.5 years into the contract, the steel company decided they were paying too much for the oxygen, and they told the oxygen company, if you don't lower your price, we're going to stop making steel for the next 6 months. And if we stop making steel for the next 6 months, our requirements for oxygen from you will be zero. And if you don't lower your price, that's what we're going to do. Then after the 6 months, we'll make up for the steel that we didn't make during the first 6 months. But trying to force the oxygen company to lower their price. Well, they obviously are now reducing their requirements. The steel company is reducing their requirements in bad faith in order to manipulate the contract. It's not a commercial, a business judgment otherwise. And so that's not permissible, whereas if in good faith the requirements are lowered all the way down to zero, that's perfectly acceptable. So the place where we are then is that in forming these contracts, we know the kind of problems that you have. You're going to have to imply some promises. And secondly, the quantity term is going to be the quantity that the parties expected, more or less, with some reasonable deviation above and or below, but it can go all the way to zero below if they go out of business in good faith. Now, with that in mind, let's look at what's required, how we can organize your analysis of a requirements or output contract. And the first question is, did you form a requirements contract? And the formation of a contract requires agreement on the essential terms, consideration, and no effective defenses. There's nothing new there. But if we are forming a requirements contract, what is it that we're going to be looking for as opposed to forming an ordinary contract? And so you look here and you say, well, to form a contract, we need agreement on the essential terms. How do we get agreement on the essential terms? Well, you can use the offer and acceptance process to get it, or the bar examiners might tell you that the parties agreed on the parties' price, subject matter, and time. So the bar examiners might tell you that the parties agreed on everything, or they might make you establish that the parties agreed by going through this offer and acceptance process. So if you go through the offer and acceptance process, then you need, the offer requires intent to contract. Now the requirements contract don't have anything special here. Essential terms and communication. It's in the essential terms that you need in the offer where you get something special regarding requirements contracts. And you see here the essential terms are parties, price, subject matter, and time for performance. And we all know that. But it is the subject matter of the contract where you must identify the item and say what the quantity is. And in an ordinary contract, you just give the quantity. But in a requirements contract, this is where the issue comes up. And here's where you use 2-306. And you say that although the quantity is not specified, that the Uniform Commercial Code provides that the quantity shall be the quantity that was reasonably expected at the time, with reasonable variations from that, so long as their variations are in good faith. And so that's what you would say here regarding this formation of a requirements contract. So one thing you would write about here is continuing. You're still forming this requirements contract. Parties, price, subject matter, discuss the quantity thing here. Time for performance. Now in these requirements contracts, there's another issue you will need to mention, because requirements contracts need a specific time. If I'm to sell goods to you and we don't say when they are to be delivered, then I just have to deliver them within a reasonable time. But if I'm going to meet all of your requirements of some sort, I need to say for how long. So the requirements contracts need a specific time, whereas reasonable time might do for certain other kinds of contracts. So these are two things that you would need to discuss in the formation of a requirements contract if you had to form it through the offer and acceptance method. If, on the other hand, instead of you having to form it through the offer and acceptance, they told you that the parties agreed on what the price was and what the items were and what the time for performance was, but if they agreed on that that one party is to meet the other's requirements, well, once again, you've got a requirements contract and you need to discuss it there, and it needs a specific time. So whether the quantity and the time are given to you or you have to establish them from the facts, these are issues that come up when you are forming a requirements contract. Next, consideration. This is another issue that comes up when you're forming a requirements contract. In an ordinary contract, you know about consideration. You know, legal detriment must be there. In the case of requirements contracts, you will have consideration issues there. And the consideration issues in the case of requirements contract are, first of all, you know the common law history. And the common law history was that these contracts were treated as illusory. They were illusory on the grounds that the person's requirements might go to zero. And so and that's no longer the case. At common law, under requirements contracts, remember that the exclusivity may be implied, and you're almost sure to have to make an argument about something being implied in the formation of the contract, either my promise to buy exclusively from you or your promise that you're going to meet my requirements. Because even if I say to you, I'm going to buy all my fish from you, nobody else, don't worry about a thing, I'm going to buy all my fish just from you. Well, you didn't promise back that you would supply me with all my fish, and so we don't have a requirements contract. You just have me making a continuing offer. So you got something's going to be implied. You're going to have to deal with that in the answer to your question, and as I mentioned here, distinguish it from continuing offers. Finally, defenses to formation of these requirements contracts. The usual defenses: statute of frauds, fraud, duress, unconscionability, lack of capacity, and so forth. But there's some special stuff that comes up under requirements contracts under the statute of frauds, and you often have a chance to discuss this. In the statute of frauds, first of all, you need to keep in mind that a requirements contract is not a sale of goods contract. Okay? What I'm promising you is that if I buy any motorcycles, I will buy them just from you. If I buy fish, I will buy it only from you. But I don't have to buy any fish at all so long as I'm acting in good faith. And so the requirements contract itself is not trading in goods. It's making a deal that when I do trade, I'll trade with you. Now, there's no sale of goods. Statute of frauds says sale of goods for a price of $500 or more, you need a writing. Well, even if I'm agreeing to buy Rolls Royces and they cost a lot of money, and I'm going to buy them exclusively from you when I'm ready to buy them, okay, this is not a contract for the sale of the Rolls Royce. Okay? When I want to buy the Rolls and we negotiate that, that's a contract for the sale of goods, and you may need a writing for that. But the contract, the requirements contract itself, the $500 rule does not apply because it's not for the sale of goods. It's for a promise to do business together. The 1-year rule, however, of the statute of frauds can be an issue. Suppose we say that I will meet all your requirements for the next 2 years. Now, if I'm going to meet all your requirements for the next 2 years, then we have a contract which by its own terms cannot be performed within 1 year, and therefore we need a writing to satisfy the 1-year provision of the statute of frauds. What about that one? Well, there's a split of authority as to what happens there. And the reason there's a split of authority is because if the contract says that I'm going to meet all your requirements for the next 2 years, well, I can go out of business during that 2-year period. I can go out of business in a week. And therefore, the whole thing would come to an end in less than a year. So some jurisdictions say, well, my going out of business, isn't performing the contract. That's terminating the contract. They're saying you can always terminate a contract. You can terminate by breaching. So the fact that you can terminate in less than a year is not what that statute of frauds provision was about. And that if I simply go out of business, that terminates. And therefore, that doesn't count. And so if the contract is good for 2 years unless I terminate it, well, I still need a writing to satisfy the 1-year provision. But other jurisdictions take the other position. They say, well, look, when I negotiate a contract with you, I'm going to buy all my requirements from you for the next 2 years, all my requirements for fish from you for the next 2 years. Well, if I go out of business, some jurisdictions say, well, the option of going out of business for the next 2 years is just considered one of the alternative ways to perform my contract duties. That I can perform my contract duties by dealing exclusively with you or by going out of business. That's a built-in optional term of the contract. So going out of business is performing the contract rather than terminating the contract. So it depends on which way you look at that, you do or don't need a writing. If going out of business is an implied term of the contract, I can always do that in less than a year. So in that case, the requirements contract does not need to be in writing. But if going out of business is just another way to terminate the contract, well, then I still cannot perform the contract within 1 year. In that case, the requirements contract will need a writing. Now, so that is what you need to know about these requirements and output contracts. It was tested. Let me give you a couple of examples of where it was tested. One, the fish case I just gave you. And what happened in the fish case is interesting because the situation there is you have the fish company, and the restaurant, and the restaurant had promised, I will buy from fish only. And the fish company says, I will sell restaurant all requirements. So we have a contract, a requirements contract. Now, in this problem on the real bar, two things happened. One is this restaurant opened a catering business to go from the restaurant, catering. And the catering business increased their demand for fish by 25%. So here's your increase in demand. They were doing great. So your first question here is, do they have a requirements contract? If they do have a requirements contract, was this increase something that is within their expectations? And obviously you can argue both ways. And you make an argument. I don't have to tell you what those arguments might be. So this is or isn't within their expectations. But in any case, fish company was supplying the fish. And then guess what happened? There was an oil spill. And because the oil spill, fish company couldn't get enough fish to meet all the requirements for all of its customers anymore. So we have two problems. These people have increased their demand, and the supply here is diminished. So over here, what you needed to discuss was commercial impracticability. Because when the fish company went out to get fish after the oil spill, they went out to get fish. They had to go further out to get the fish. They stayed out longer. They caught fewer fish when they were out. And so it was costing them a lot more to produce the fish because of the oil spill. And they couldn't produce all that they were required. So you may have commercial impracticability. You may have impossibility. Need to discuss that. And finally, what fish company is required to do when they cannot meet they have a number of restaurants, is they are to distribute what they can get pro rata among these restaurants if they all had requirements contracts. And so some kind of a pro rata distribution. So a fish company would like to get out of the contract on one of these bases, because if they can get out, they can now get the higher price because everybody has to charge more for the fish now. So if they can get out of their requirements to terminate the contract on one of these bases, they can collect current prices. Otherwise, they're going to have to distribute pro rata. Now, so that was one question on the bar. Another question dealing with this class of contracts was a question where a company said there was a contract between a manufacturer and a hauling company. And the contract said that the hauling company will provide all of the hauling, will provide all the hauling requirements of manufacturer. Okay, the trucking company will provide all of the hauling requirements of the manufacturer. Well, you got a problem here, because it sounds like the trucking company says, we're willing to provide it all, but I don't see the manufacturer saying, we will deal exclusively with you. Now, unless you can find something in the facts where the manufacturer was impliedly promising that I will deal exclusively from you, you don't have a requirements contract, you have a continuing offer from the trucking company. And indeed, the way the problem was constructed, if you found a requirements contract, certain consequences came out. If you found they did not have a requirements contract but a continuing offer, another set of consequences. And that's the way the problem was constructed. One other problem, there was a couple named Katie and Mike that owned a motorcycle dealership, and Cycles was the supplier of the motorcycles. So they formed a contract, and the contract said Cycles will supply all the motorcycles that Kate and Mike require. Cycles will supply all the motorcycles that Kate and Mike require. Well, right now, we don't have them promising back to buy exclusively from Cycles. But if it turns out that Cycles is the only place they can get the motorcycles, if they open a Harley-Davidson dealership Where else are you going to get the motorcycles from except from Harley-Davidson distribution system? If you got a Yamaha dealership, you're going to have to get them from Yamaha and so forth. And so there, you can imply a promise from the Kate and Mike that they would buy exclusively from Cycles because that may be the only place they can get the motorcycles. So that's another example of the implied promise. And indeed, the outcome of the problem turned on whether or not you found that they did or did not have a requirements contract. Don't forget the statute of frauds, the split of authority on statute of frauds. You may or may not need the contract in writing. If I promise to buy all the pens I require from you for the next 6 months, and if I promise to buy all the Rolls Royces I require from you for the next 6 months, neither of those is trading in goods. Okay. When we actually make the deal to buy the pencils or the Rolls Royce, we're trading in goods. And so the $500 rule does not apply. I think that's everything you need to know about requirements and output contracts and exclusive dealing contracts. I hope they give you one on the exam. You should do well. That is the end of this lecture.